Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We are here today for oral argument in the case of Backstrand v. Backstrand 1 CACV 19-0742. Each side is allocated 20 minutes for oral argument. If you wish to reserve some of your time, appellant, please feel free to do so, but you'll be responsible for keeping track of it yourself. I believe you can see the clocks there in front of the thing. As you can see, we're not going to use the podium today so that we can all maintain some distance. While you're sitting at your council table, at least you, since you're socially distant, if you want to take your mask off, you may, or you can leave it on. It's entirely up to you. We have conferenced this matter this morning, so we are familiar with your briefs and with the record. So keep that in mind while you make your arguments. We will be live streaming this, I believe. So I'm sure the crowd of ones will be watching with bated breath. But we'll also be posting it on YouTube later. So you can go back and critique yourselves and us. Though don't spend a lot of time critiquing us, but you can if you want to. And keep that in mind. So when you're speaking or when you first start speaking, please announce who you are and who you're representing so that people watching can figure out who the parties are. Have I missed anything? I think I covered it all. Mm-hmm. With that, we will begin. Counsel for appellant.
Well, that's a little different than what the parenting plan required, isn't it? Because didn't the parenting plan specifically require that Lola attend the school in Lake Havasu?
It did, Your Honor, and that was just painful enough for the
Well, except once you make a determination that the parenting plan needs to be modified, doesn't the law require that you go through a complete 403 analysis?
Yes, Your Honor. Again, though, I think
Well, hold on, because you said it needs to be detrimental. So let me give you a hypothetical. And that hypothetical is the parties are divorcing, whatever. And one of the parents, and we'll just designate father, has cancer. And so he's going through a lot of treatments, and they're not even sure if he's going to survive. And so he has basically no parenting time. After a year, he's completely cancer-free, and he says, I want parenting time. Now, there would be no detriment to the child at all. It's only a benefit to the child to now start having parenting time with father, but under your analysis, that's not a change in circumstance. Well, thanks, I'm glad I thought of it.
the case law does say, and this is where I'm getting it from,
But isn't that this part two of the analysis? I mean, it's a change in circumstances that's detrimental to the child is where you're considering the child's best interests. And you're referring to Davis, I believe, right? So when I'm just asking kind of like when you're saying the case law says, I always go, which case and where? So. I think I derailed Judge McMurdy's question, though. You acknowledge it's a good hypothetical, but your position would be under Black v. Black. Sorry, that's not a change in circumstances, and because it's not detrimental, so therefore it would not allow the court to reopen or reconsider parenting time. I just wanted to make sure your position was clear.
So I just so we're clear, your answer to my hypothetical is, oh, too bad, sick dad. Sorry you got better. You're just not going to get any parenting time. Well, if we can say that in that case, why can't we say it in this case? If we can say it in that case, why can't we say it in this case?
But counsel, your position is not only that it was not a detrimental change, but that it was not substantial. Is that correct? Even though the child is changed, everything about the child's life changed. Moved to a new state, new school, just new day-to-day activities. Your position is that is not substantial.
Well, but the parenting plan, that would be a change, though. I mean, you can move 100 miles, but if the parenting plan says you have to attend school A, you have to attend school A or get court permission to change it to school B. The 100 miles doesn't change that. But I mean, if there's a court order that says, and that's what the parenting plan is a court order that says you shall attend this school, the 100-mile exception that you can move your child without that does not change that you need new court permission to attend a different school. Okay, but because it seemed like you were arguing that, well, as long as since you can move in the 100 miles, you can change schools and do things without it being a change in circumstance. And let's say I could agree with you and say, maybe you're right that should, but isn't that what we entrust trial courts to figure out, is when there has been a change, that what is required to achieve the best interest of the child after that? So why are we in a better position to decide that what's in the child's best interest in the court?
Well, hold on, because the 100-mile is just whether or not you need to seek court permission or keep permission. If mother had just moved 100 miles, and I don't know where that puts her in relation to Lake Havasu, but let's just say 90 miles, you're hypothetical. Father could still have petitioned to modify the parenting plan based on that 90-mile road. There's nothing that says you can't, that a move is not to be considered if it's less than 100 miles, right? Right. Well, let's play with this for a minute, just so that I can make sure I understand your position. If mother had moved across the street, obviously, that's not really a change in circumstance. I mean, the child still has the same environment, as Judge Cruz pointed out, the same schooling, the same everything. But what if she had just moved across town, so the child is no longer in the same school, no longer has the same play friends in the neighborhood, no longer has some of the other factors that go into where the child is living? Isn't that something also the trial court should consider?
But then by the same token, when you have a parenting plan, and one of the parents unilaterally changes it, shouldn't the other parent be able to say, we are not in the same parenting plan that we were before?
Theoretically, you're right. But wouldn't that, I mean, at the end of the day, aren't we talking about a best interest analysis under 403? Which the trial court did.
Earlier, you complained, and not, I don't want to overstate it, but you pointed out that the court had not made findings regarding substantial change. Did you even argue this below, that the court, there hadn't been a significant change in circumstances detrimental to the child, and therefore the court was not allowed to reach the best interest issue? I mean, had you basically teed it up for the court so it knew it needed to make these specific findings you're referring to?
Well, except I read your pretrial statement, and I didn't see that argument made in the pretrial statement. Isn't the case law saying you've waived it if you don't put your claim in the pretrial statement? Well, the rule says that. But the claim is that there was not this does not constitute a substantial change. And you believe that that claim is subsumed in the three issues that you just listed?
But there's nothing in there that says we shouldn't even get to this point, or there was no change in circumstances. Okay. Yeah, 5 minutes.
Well, I would say I'm sorry. I'm sorry I keep interrupting, but when we're talking about due process, the family rule says that we are not to reverse unless we find prejudice. So the question I have for you on this point is, when the trial court said, "I'm only giving you an hour," and he said, and there was an objection to that, but after an hour where she testified, did he say, "Judge, this is what I need to present that I wasn't able to present within my hour, 50 minutes"? I understand. Did he make an offer of proof? Did he object? Saying, "I'm now object because I wasn't able to get that all in my 50 minutes."
But aren't we talking here more about the timing of it, not necessarily magical words, but rather that the circumstance now, even after the hour, is such that she has not been able to fully present her case, that there's still something she needs to introduce?
Isn't a large part of that because the cross-examination, you referenced the direct father, but wasn't a large part of that the cross-examination of the father that went on for quite some time? Getting back to Judge McMurdy's, and you've got 1:20, so if you want to reserve your time, I'll come back to it later. You want to reserve a minute for a rebuttal? Okay. Thank you. It's up to you. If your co-counsel there isn't too worried, I guess we don't mind. Okay.
My name is I represent Backstrand. This is the case of issue of and the trial was going to be applied. And they court required the client to understand something not only explicit but active. So the counsel is speaking, they're not required to even do that. The finding itself is a change of location. And the elevator in the room here, this wasn't down the street or even in the next city. This is a whole other state that mother and she did it without a court. It's important to understand the procedural history. It had absolutely no court order to look at the other state. The court order explicitly stated that the child was supposed to be in a specific school atmosphere and in the atmosphere of that. She moved without that order. Under testimony, during the trial, she believed, the mother testified that she believed she had to. That was clearly wrong. On October 3rd, 2018, it was a short period when the judge didn't grant any dismissal. And at that point, the mother mistakenly thought actually how the order was. And then she moved shortly after that. The court re-objected the trial, straightened the plea, and did everything to get the stop. That change in itself in the location from Lake Capital City to Las Vegas isn't enough to be able to stand up.
Well, Davis does say what it says. Davis says detrimental, right? Okay, so what's different today than when Davis was decided back in 1954? Well, that's why I asked the question. Explain it to me.
We're talking about entire different things. We're talking about it's not just the detrimental effect, it's also a beneficial effect. And that's partly what happened here. It was a beneficial effect of the capital itself with more stability. And I just like to add to that, does go off with the question. The court did create a finding of the capital. It specifically stated it talked about that had to be explicitly stated that the minor child was essentially stable prior to the mother disrupted that. That right there is proven to say that there has to be a meaningful detrimental effect right there. But I don't even think the court's required to be something that is substantial continuing for that matter.
But does, and res judicata is not the exact concept, but does res judicata mean anything if it can be a change, even a positive change, that can trigger a material change in circumstances? So, for example, if the mother was the ill one, reversing Judge McMurdy's example, and she had parenting time but was having trouble exercising some of that parenting time because she was ill, and then got better, could the father go, well, it's been a change in circumstances, she's better now, so we can go back and give me more time? Doesn't make any sense as to why that would be the case, but it is a change in circumstances.
And Your Honor, I think you bring up a good question. I think you need more than that. But I think what's going on in this case is that the court order was followed, and also there's a school location involved in that that's not necessarily mentioned in the newspaper. In addition to all that, there's other huge change in circumstances, and that's the change of the stepmom. About her mother's actually criminal in that time between the original retreat and our trial. And that's basically the only sibling. And for access, basically...
Was that something that you guys had alleged as a change in circumstances, or was that something you guys just offered to show best interest at the time?
We presented proofs regarding best interest. I do believe my client talked about how that was a positive issue that we have there, and like those presented especially with the issue that there was no sure of that stepmother at the time.
But he hadn't gone to Lake Havasu either.
Your Honor, I would say that all the way up until the time of the treaty plus
In Lake Havasu?
they were still in Flagstaff.
Okay.
And plus the camp all the way to the creek, and then mother chose to turn it right. And after that, and Your Honor, I would basically forward that it's not just the move, it's the move plus. It's move, school, it's the lack of stability, or it's just talks about, in addition to that, the liver quality disorder. And with all those circumstances covered, the court not only explicitly states that we can't fulfill the ability, there could be also an implicit in their response. Moving on to the second issue, I would have to disagree with how opposing counsel applied. It was not a situation that examination on the trial case. It was a situation where a decision was made by appellant trial court counsel to substantial amount on cross-examination, so much that we actually asked for the extra day. Granted, we got the extra day, but even then, we still, his questions still went on to the such where, of course, at lunch, it seemed like he didn't even have an idea that he was getting at the time. He made a strategic decision to push his case, and his case went through cross-examination of the various things.
I know in your briefs you talked about page numbers of transcripts. Is there a sense of time that you could give us?
Your Honor, being the trial counsel for I was there.
Well, I know a lot of times transcripts say, direct began at this time, ended at that time.
Unfortunately, time markers are not there. They're not there. That's what's happening. And, Your Honor, I think there's an argument that cross-examination is longer than direct. If you actually look at the examination, trial counsel will tell you that actually asks pretty wide open questions for both our expert, Kelly's expert, and as well as the Kelly itself, which take up the lion's share of the time of the case. And to answer the question earlier, just to state that it's not just what happened, it's also the reaction that trial counsel or the appellant had to the situation. The first objection was we possibly suspicious. But even more important, didn't make an offer of proof at the end. We had time at the end. We had over 20 minutes of closing argument that we could easily be converted into trial or testimony. And that was even before the court. Literally, the only objection put forward by the appellant trial counsel was the one objection that we stated in the brief, where that itself is a kind of, it doesn't even say that I want to get in your face, Judge, but I'm going to have to just do this. And then after that, proceeds to have a robust back and forth with the client. And all that evidence we need from her, that's not in the brief. Really, this all boils down to the issue. Mr. Buckman.
Did Mr. Buckman's report make it into the record? So the trial judge had Mr. Buckman's opinions.
Not only did she have the trial case, she had his testimony the first morning, and at that point, the appellant could have cross-examined him at that point. Later that afternoon,
But there was some discrepancy with Mr. Buckman about his memory or his ability to recall the case.
And again, Your Honor, I don't think that should have at least to testify any time. In character trial, the judge was insistent that Mr. Buckman go first down to the state. And in order frequently to get needed or appoint expert to testify about Mr. Buckley. So his report was in his part that was the most we got in there, and discussion began about that. So now we have multiple opportunities. In addition to that, I marked Mr. Buckley's deposition as well. And if Mr. Buckley's testimony is that important and is essential as portrayed by the appellant in this case, they could have tried to put that in. And they chose not to. Mr. Buckley sat for maybe a 4-hour deposition. And that deposition was marked. Where even and Your Honor,
I'm just going to, bailiff, next time flip the clocks. Sorry, go ahead.
Thank you, Your Honor. So, in that argument, we're basically talking about a proper that proof is not being satisfied. It really isn't a supposed proposition. It has to be there. And they had what was admitted, and it was not called documents, had absolutely trial date, had an opportunity to be supposed to call him out of order, and I discussed that with the court counsel. And then in addition, no opportunity there again. No discussion. Like, no, this is going to be a big issue here, but you might want to consider today's date not using the 20 minutes on Mr. Buckley, not wasting it on cross-examination. Could have written, could have...
You mean closing argument?
Yeah, sorry. You could have submitted closing argument. Usually done that for the solution that closing argument. The court needs to know. The court doesn't know this.
Earlier, and I'm going to change gears on you a little bit. Earlier, you said cases like Davis and I presume Black also are distinguishable, and you said you can begin with Canty, but I don't know that you actually followed up on that thought and explained how exactly we can distinguish these so we don't feel bound to follow the Supreme Court, at least the broad language in some of those decisions.
I think what's important in this case, this court has done for on all the violence.
What years wouldn't it be Whitman?
That makes sense. Is and in that case, this court went through the analysis of the situation. And this situation, ironically, others living in Arizona, fathers living in Ohio, very close to this situation. Mother then moved to Dallas, father living in Ohio. In that case, they made specific analysis. In that case, that they did find enough that was a changed circumstance. That in itself was moved by itself, putting that fact that father's parenting plan may have not moved at all. The move itself was enough. And in that case, that's even worse than the case, because the court taken the time to stretch the findings of the mother's new constitutional change, and that they used the reasoning consent to be canceled, and you then to find the specific finding in relocation, basically, the way factors, so that you not only has this, what we're arguing is the logical moves of other states, moves of schools, is substantial change of material.
Yeah, but it wasn't a published. It wasn't a published opinion, so I hesitate.
Was I on that
submit
panel?
it.
Well, then it probably wasn't very good.
Your Honor, I would just go back to the looking at the law, the thing that comes back is the stability of the fire. This is
That's not part of our record.
But, just a couple of issues, John, there, cancel.
No questions. Thank you. Ms. Wilkins, I believe you have 1:15 left, so, or 14.
That's-
Full, rather, if it was the left, 43, lifestyle, and then the first is all there, everybody gets to the front. But that actually doesn't change. Their whole, goes to the whole left, no, that was the same.
I don't.
No, thank
Okay.
you.
Thank you all, council. I appreciate your arguments today, and I believe I appreciate you that you were able to change the date. We changed the day of the conference to move it up earlier in the week, and that seemed to work for all of you, and we appreciate that as well. With that, we will take this matter under advisement and issue a written decision in due course. Thank you.